It is indeed a pleasant surprise that a law, a statute, which defines offences, which prescribes punishment, has given a right to every person under its jurisdiction. This is a substantive criminal law, IPC, and it's rare that a substantive criminal law grants rights to citizens, rights to persons living in the area of its jurisdiction. Rights are granted by the Constitution, fundamental rights or otherwise. Rights are also granted by other welfare statutes. It is indeed quite rare that a right is granted by a substantive criminal law. The next question is whether this is an absolute right. Even constitutional rights are not absolute. Even fundamental rights are not absolute. So it will not be fair to expect that this right granted by a substantive criminal law will be absolute. Yes, restrictions are there. What are these restrictions? The restrictions are specified in Section 99. So we'll have to wait for some time before we come across these restrictions. But before we go to restrictions, let us summarize the right. The right of private defense is the right of a person to defend his own body, to defend another person's body, to defend his own property, to defend another person's property, any other person's property. In the next few slides, I am going to present certain statements of law which I have collected verbatim from certain important pronouncements of the highest court of this country, that is from the Supreme Court. This right, that is the right of private defense, rests on the general principle that where a crime is endeavored to be committed by force, it is lawful to repel that force in self-defense. The rule of retreat, which common law courts espoused, is not relevant under the Indian Penal Code. In India, there is no rule which expects a man to run away when confronted with a situation where he can exercise his right of private defense. This is a very important statement of law. In India, there is no rule which expects a man to run away when confronted with a situation where he can exercise his right of private defense. So you are not expected to run away when your body is attacked, when the body of another person is attacked, when the property of yourself, of any other person is attacked. You are not expected to run away. If a man's property is in imminent danger of being impaired or attacked, he has the right to resort to such measures as would be reasonably necessary to thwart that attempt. The right of private defense is available for protection against apprehended unlawful aggression and not for punishing the aggressor for the offense committed by him. It is a preventive and not punitive right. Please remember, this right is not for punishing the aggressor after the offense has been committed. This right is for protection against apprehended unlawful aggression. It's a preventive right, not a punitive right. The right to punish for the commission of offences vests in the state, which has a duty to maintain law and order, and not in private individuals. The right to punish is not available to private individuals. If after sustaining a serious injury, there is no apprehension of further danger to the body, then obviously the right of private defense would not be available. These are some of the important statements of law which have been culled from various judicial pronouncements. Before we move on to the next section, I'll take you back to the provisions of Section 97. Section 97 gives you a right to defend your body and the body of any other person against an act which is an offense affecting human body. If the act is not an offense, this right under Section 97 is not available. Let's take the case of a person of unsound mind attacking you. By virtue of Section 84, nothing is an offense which is done by a person of unsound mind if at that moment he is incapable of knowing the nature of his act. Since it is not an offense under Section 84, Section 97 does not give you a right to defend yourself against this act of the person of unsound mind. Similarly, if you are attacked by a person who is heavily intoxicated and the intoxication was administered to him involuntarily, so it's a case of involuntary intoxication. If the level of intoxication is such that the attacker is incapable of knowing the nature of his act, how do you defend yourself against such an attacker? Such an act by this person is not an offense by virtue of Section 85, and you cannot defend your body unless the act is an offense. So the protection given by Section 97, the right given by Section 97 seems to be incomplete. We need an extension of this right. And yes, there is an extension of this right. The extension is in Section 98. This section provides the right of private defense against an act which would have been an offense, but it is actually not an offense by reason of youth, want of maturity of understanding, unsoundness of mind, intoxication, or by reason of any misconception of the doer. This act would have been an offense, but for the exception available under Section 82 by reason of youth, exception available under Section 83, want of maturity of understanding, exception under Section 84, unsoundness of mind, exception under Section 85, intoxication of the doer, misconception of the doer, exception under Section 79. If it is such an act which would be otherwise an offense, but it is not an offense because of these exceptions, then Section 98 grants a similar right of private defense which would have been available if the act were an offense. This is an extension of the right given by Section 97. Let's take some illustrations. Z under influence of madness attempts to kill A. Z is guilty of no offense. Why? Because of Section 84. His act is under unsoundness of mind. If the unsoundness is such that Z is incapable of knowing the nature of his act, then Section 84 declares that he is guilty of no offense. His act is not an offense. Section 98 says that despite this, A has the same right of private defense which he would have if Z were sane. If Z were sane, then his act would have been an offense. If his act would have been an offense, the right of private defense would have been available under Section 97 itself. The same right is now given by Section 98. Another illustration. A enters by night a house which he is legally entitled to enter. Z, in good faith, taking A for a housebreaker, attacks A. Here, Z, by attacking A under this misconception, commits no offense. Z believes himself to be justified by law in attacking A. How is he justified? The right of private defense, which we are now talking of, that right is available to Z. A is committing an offense. He thinks in good faith that he is committing an offense against property, and section 97 gives him a right of private defense. He is under a mistake of fact that he is justified by law in attacking A, and he attacks A. His act is not an offense, but still, because of section 98, A has the same right of private defense against Z which he would have if Z were not acting under that misconception.